If you or your partner lost the ability to make decisions tomorrow through a stroke, a fall, or the sudden advance of a condition you already know about, your spouse could not access your bank account. They could not pay your bills. They could not make decisions about your care, not automatically, not legally, not without going to court. Most people assume marriage changes this. It does not. Most people assume the next of kin rule covers it. There is no next of kin rule in English law for financial decisions. If you do not have a lasting power of attorney in place before you lose mental capacity, the only route left is the court of protection. And that process costs more, takes longer, and gives you far less control than doing it now for £184. That is the number I want you to hold in your mind for the next 15 minutes. £184. That is the government registration fee for both types of lasting power of attorney for one person in England and Wales in 2026. You can do it yourself online. You do not need a solicitor, and it could protect everything you have spent your life building. This channel is not affiliated with the DWP, HMRC, or any government body. Everything here is for education only and is not personal financial or legal advice. For complex family situations, please do take independent legal advice. Let me start with what a lasting power of attorney actually is, because the name puts people off, and most people have only a vague idea of what it covers. A lasting power of attorney is a legal document made under the Mental Capacity Act 2005. It allows you, while you still have mental capacity, to appoint one or more people you trust to make decisions on your behalf if you later lose the ability to make them yourself. The person making the LPA is called the donor. The people you appoint are called attorneys. There are two completely separate types of lasting power of attorney in England and Wales, and they cover different areas of your life. The first is the Property and Financial Affairs LPA. This gives your attorneys the power to manage your money and property. They can operate your bank accounts, pay your bills, collect your pension and benefits, deal with your investments, sell your home if necessary, and manage any other financial affairs. This type of LPA can be set up to take effect immediately on registration, meaning your attorneys can use it even while you still have capacity with your permission. This is particularly useful if you have mobility problems or simply want help with financial admin. The second is the Health and Welfare LPA. This gives your attorneys the power to make decisions about your medical treatment, daily care routine, where you live, what you eat, what activities you do, and whether to consent to or refuse life-sustaining treatment if you choose to include that option. This type of LPA can only be used once you have lost mental capacity. It cannot be used while you are still able to make your own decisions. Most people need both. They are separate documents and they attract separate fees, but they work together to cover your whole life. The government registration fee in 2026 is £92 per LPA, making £184 for both. For a couple making both types each, the total government fee is £368. If your gross annual income is below £12,000, you pay half that, £46 per LPA instead of $92. If you receive certain means-tested benefits, including pension credit guarantee credit, housing benefit, income support, or income-related employment and support allowance, you may pay nothing at all. The fee reduction form is called LPA 120 and it is submitted alongside your registration. These reductions are not automatic. You have to claim them. There is one very important thing you need to know before we go any further. An LPA cannot be used until it has been registered with the Office of the Public Guardian. Signing the forms is not enough. Registration is a separate step, and in 2026, the Office of the Public Guardian's standard processing time is approximately 20 weeks from receipt of a correctly completed application. That is 5 months. If something happens to you during those 5 months, after you have signed but before registration is complete, the LPA cannot be used yet. The registration is what gives it legal force. This is why the advice from every solicitor, every care organization, and the government's own guidance is the same. Do not wait. Start the process now while you have capacity and get it registered while your health is stable. Because here is what happens if you do not. If you lose mental capacity without a registered lasting power of attorney in place, your family faces the court of protection. There is no other way. Even your husband or wife cannot legally manage your finances without a court order. The bank will freeze your individual accounts. Your pension payments may become inaccessible. Bills stop being paid or fall behind. And the person who loves you most has to start a legal process that will take months and cost significantly more than an LPA would have. The Court of Protection application fee alone is £432. On top of that, there is a one-off appointment fee of £100 and annual supervision fees of £320 every year for as long as the deputyship continues. If a solicitor is handling the application, which most families need given the complexity, add a minimum of £950 plus VAT, and often considerably more. In a straightforward case, the first year of deputyship costs a family upwards of £2,000, and those fees come every year, indefinitely, for as long as the person lacks capacity. One published example from a legal practice calculated that a professional deputyship running for 10 years would cost over £34,000 in total solicitor fees alone, on top of the court and OPG fees. A lasting power of attorney costs £184, set up once, and there is something the financial cost does not capture. The Court of Protection process takes time. During the months it takes to obtain a deputyship order, your family may be unable to access money to pay for your care. Local authorities can sometimes step in, but the gap is real, and the stress on the people trying to help you is significant. There is another assumption that catches people out, and it is one I want to be very clear about. Being married does not give your spouse automatic legal authority over your finances or your healthcare decisions. If you are admitted to hospital and you cannot communicate your wishes, the hospital will try to involve family, but they are not legally bound to follow a spouse's instructions on medical treatment without a Health and Welfare LPA. If your individual bank account is in your name only, your spouse cannot access it without a Financial Affairs LPA or a court order. This surprises almost everyone. It surprised the families of the nearly 1 million people in the UK living with dementia who never got round to putting an LPA in place. Now let us talk about how you actually do it, because this is the part most people assume is complicated. It is not. The government has a free online tool at gov.uk. Search for Make a Lasting Power of Attorney. The tool guides you through both types of LPA step by step. You choose your attorneys, any replacement attorneys if your first choice cannot act, and any instructions or preferences you want to include. The tool is free to use. The only cost is the registration fee when you submit the completed forms to the Office of the Public Guardian. Before your LPA can be registered, there are a few important steps. The forms must be signed in the correct order. Signing out of order is one of the most common reasons applications are rejected, which means starting again and paying the registration fee a second time. The order is: first, any named people who should be told about the LPA sign to confirm they have been notified. Then you, the donor, sign. Then your certificate provider signs. Then your attorney sign. Do not skip any step or change the order. The certificate provider is a specific role. This is a person who signs to confirm that you understand what you are doing, that you have not been pressured or coerced, and that you have the mental capacity to make the LPA. The certificate provider must be someone who has known you personally for at least 2 years, or a professional such as a doctor, social worker, or solicitor. They cannot be a family member, a business partner of your attorney's, or someone who would benefit from the LPA. Choose this person carefully and speak to them before you begin, because the LPA cannot be registered without their signature. Once everything is signed and in the correct order, you send the forms to the Office of the Public Guardian with the registration fee. Allow 20 weeks for processing. When registration is complete, the Office of the Public Guardian will return the registered documents to you with a stamp on each page. Keep these documents safely. Tell your attorneys where they are. The LPA is no use to anyone if it cannot be found when it is needed. In Scotland, the process is different. The equivalent document is called a Continuing Power of Attorney for Financial Matters and a Welfare Power of Attorney for Health Decisions. These are registered with the Office of the Public Guardian Scotland, and the process has some important differences. If you are in Scotland, search for Power of Attorney Scotland on the GovScot website. In Northern Ireland, the relevant document is an Enduring Power of Attorney for Financial Matters, and it is not registered until capacity is lost. The rules there differ significantly from England and Wales. Here is the part most people miss. You can make an LPA even after a diagnosis of dementia or another condition that affects cognition, as long as you still have the specific mental capacity required to make this particular decision at the time you sign. Capacity under the Mental Capacity Act is assessed decision by decision, not as an all or nothing status. A person with early stage dementia may still have the capacity to make an LPA, but the window may be shorter than you think. A solicitor or GP can carry out a capacity assessment if there is any doubt, and having that assessment on record protects the LPA from later challenge. If a family member has recently been diagnosed and has not yet made an LPA, the most important thing to do is begin the process now rather than waiting for a crisis. Here are your action steps. Step 1. Go to gov.uk and search for Make a Lasting Power of Attorney. Create a free account and start both the Property and Financial Affairs LPA and the Health and Welfare LPA at the same time. Step 2. Choose your attorneys carefully. They should be people you trust completely, who are organized and willing to take on the responsibility, and ideally, who do not all live in the same household as you, so that the LPA remains useful if the household is affected by an emergency. Step 3. Identify your certificate provider. Speak to them before you begin the forms. They need to understand their role and be willing to sign. Step 4. Check whether you qualify for a fee reduction. If your income is below £12,000 a year, or you receive a qualifying benefit, complete Form LPA 120 when you submit your registration. Step 5. If you have a family member who you believe may be losing capacity, do not wait. Make an appointment with a solicitor who specializes in this area, or contact Dementia UK's Admiral Nurse Service for guidance on the right steps. The Dementia UK helpline is 0800 888 6678, and calls are free. £184, done once, while you have capacity, or thousands of pounds paid indefinitely after the moment has passed. The decision is only available to you while you can still make it. And in the next video, we are going to look at something that connects directly to today's topic: the financial support available to the partners and family members who are doing the caring, and the specific benefits they may be missing while they focus entirely on the person they are looking after. That is coming up next.